Chairman, for having this hearing, and I yield back.
Gentleman yields. Mr. Liccardo of California is now recognized for 5 minutes.
Thank you, Mr. Chair. Thank you to all the witnesses for your statements. I appreciate my colleague Congresswoman Williams' frustration with the focus of the subcommittee on historic analysis of regulation, which I think I might agree with many of the assertions made that in some cases may have been overreach, in other cases I don't think so, but regardless, this administration is no longer in office. I'd much rather focus on a forward-looking approach of what we can do to make things better. And I think debanking and access to banking services is a serious concern. And I hope that, Mr. Chairman, that all of us will agree that we need a strong Consumer Financial Protection Bureau to ensure that access to banking services is widely available, in addition to addressing concerns about banking regulators and its impact on debanking. We've got about 5.6 million low-income households that critically need access to banking services and aren't getting them. So I hope we can be more forward-looking going forward. On that note, I'd like to consider the larger questions that Mr. Campbell raised about banking regulation generally. I thought those were interesting, and I want to pose the question to Ms. Forgive me, Alishik? Thank you. Thank you for your patience with my pronunciation. I know you've raised obvious concerns about regulation of banks in the context of a digital asset that may have, for example, high volatility. Mr. Campbell recommends, though, as we're thinking about banking regulation generally, that regulators going forward approach regulation in a way that is, and I'm going to summarize here, not perfectly, but first that the regulation be written, not oral, that be public, not secret, that be explanatory of a rationale used to reach the decision, and there be some, for lack of a better term, subject to appeal by a third entity. And I'm just curious about how your view of banking regulation, does that make sense as we think about how we can do better going forward?
Thank you for the question, Congressman. I actually agree with a lot of those suggestions. I think we need to start with the perspective that regulators must take a risk-based approach to this issue. And regardless of the industry, crypto or otherwise, regulators must look at what risk that's presenting to an individual bank or to the banking system in general, looking through the lens of financial stability. With regard to the solutions and a way forward, and I describe this more in my written testimony, I have two main suggestions. First, clarity on rules and expectations for banks. I think that will set a level playing field for everyone involved. And secondly, more disclosure requirements for banks. I think this will help. It will help on the clarity, but it will also ensure that if someone, whether they're a crypto customer or a minority customer who's trying to get access to banking, they will understand why they're being told no.
Thank you. I want to go to Ms. Greenwald for a moment. I understand the FDIC has announced on Wednesday that withdraw its current guidance to banks on engaging in crypto-related activities. I know you've urged withdrawal of the OCC interpretive letter, I think it was 1179, which you found to be inconsistent with prior OCC letters. To what extent does the FDIC's action address your concerns? Do we still need to withdraw somehow or another, enact legislation that would force the withdrawal of that OCC?
Thank you, Congressman. I think the FDIC's announcement was a positive step, but I don't think it goes far enough. The fact of the matter is that in response to the Inspector General's report, the FDIC committed to conducting risk assessments of the crypto activities that the banks wish to engage in. And to date, we have no indication whatsoever that they did any assessment of the risk that they claim were so significant that they couldn't even allow the banks to participate in those activities at all. The other thing I would point out is that the FDIC, in response to our requests, abused the confidential supervisory information designation to redact page after page of materials in ways that were rejected by a federal court. That needs to be addressed. Finally, in response to an order from a federal district court to produce these pause letters that we were referencing, the FDIC misrepresented that its productions were complete. So I do think there's further work that needs to be done in order to restore public trust in the FDIC, but at a minimum, I do think that the announcement yesterday by the FDIC acting chair was a constructive one.
Thank you. Thank you, Mr. Chair. I yield.